Alrighty. Hi, everyone. Welcome to week 11 of Animal Law. This is our final substantive week of the unit. So, yeah, it's a great, really interesting, very topical theme this week, and one that I think we should be able to have a lot of good discussion with. Before we get, so I should say what the topic is: animals being used in sport and for entertainment. So, yeah, certainly one that I don't think it's ever not been controversial, but my impression is that the controversy has elevated in recent years, which does make it really, really interesting. Before we get underway, a couple of bits of housekeeping. First one being, in case you haven't seen the announcements or the note on Moodle, it is a little bit tricky to find. It sort of gets buried on the assessment page, but the date and time for the take-home exam is Tuesday, the 15th of February, and it's a 6-hour exam from 3 p.m. till 9 p.m. Queensland time. So I've just had a few questions about that by email. So just, putting that out and in another source of information to make sure that everyone is aware. So of course, hopefully, I think a lot of you have already done these sort of take-home style exams before, but for anyone who hasn't, obviously it's take home in the sense that it's online and you're doing it at home, but it's very much treated as an exam rather than an assignment, in the sense that you've got this set 6-hour window in which to do the exam. You can't really get extensions. You can get a deferred exam, but only under some pretty extreme medical circumstances and things like that. So it's in your mind, it's better to think of this as an invigilated exam. And then, so just being sort of clear, and the other thing, so you can't get an extension. You also can't submit late. If you miss the sort of that 9 p.m. cutoff to submit your answer, you unfortunately miss the boat and you get a 0. So really making sure that you're prepared and on the ball for that take-home exam is really important. So yeah, just putting another that information about the date in another form so that hopefully everyone sees it and can plan their time accordingly. Next week is our revision week. We'll be spending a lot of time talking about the exam, how to prepare, all that sort of stuff. But for now, a few points, just because I put them on Moodle last week. The topics, the exam questions have been worded in a way that gives you some flexibility in the way that you answer them. And some of them are a little bit more specific, and they ask you, there's less variation, but others are much broader. And what that means is, on the one hand, potentially the entire unit is accessible in the sense that you can draw on information from any week or multiple weeks. But in saying that, I don't want to freak you out in the sense of, oh my God, I have to know all the information. Instead, really what the questions are designed to do is to give you, they ask you about sort of deeper themes or principles or ideas that have kind of cut across weeks. And then from there, you're kind of free to choose examples from 1 or 2 weeks. And, you within reason, you pick the weeks that you know the most about, or that you found the most engaging or interesting or whatever. So there's, in terms of thinking about your revision, the two sort of pieces of advice that I have for you, first is, making sure that you're across everything, but you don't have to be necessarily across all the absolute details of every week. Instead, making sure that you're engaging with some of the broader themes and being able to draw out different examples from different weeks for those themes. And then the second thing to thinking about revision is using the tutorial questions as sort of good practice. So we'll be talking through sort of the tutorial questions in general next week as part of the revision discussion. But what I'll also do later this week is I'll pull out some of the tutorial questions that I think are going to be the most useful or best prepare you for the exam. And the key caveat that goes with that is I won't be pulling out the questions that are on topics that are on the exam necessarily. But what I will be doing is pulling out questions that are most similar to the style of question or that will use the same skills as the exam question. So I'll include sort of some instructions with that when I do put that out later this week. But that's something I suppose to be aware of. And if you're looking to sort of start with your revision, working through those tutorial questions is going to be a good way of doing that. And then I suppose lastly, thinking about revision next week is going to be a 2-hour rather than a 1-hour tutorial to really kind of make sure that we're fully revised and have a chance to go over everything and all your questions and concerns as well. So I think that's in the unit profile somewhere that it's a 2-hour one. So we do just have that extra little bit of time, which is good. Any questions about revision or the exam at this stage?
I've got a couple of questions.
Yep.
First one is that our assessment 2 was based on week 1 to 5. So does that mean that the exam will be based on weeks 1 to 12? Because some subjects will sort of say to you that, look, we've done up to week 5 with the assessment, so we're only assessing from week 6 onwards. But I take it from what you're saying that you're going to be assessing, or we need to be knowing all of the weeks from week 1 to, I think it's 11, isn't it? Yeah.
Yeah. So there's everything is, I suppose, potentially accessible. And I'm trying to be helpful without giving too much away, but the key thing that I would, I suppose, encourage people to be doing with their revision is, don't necessarily try and I think the sort of doctrinal, so there's going to be some questions that are more discursive, and then there's going to be some questions that are more doctrinal. So pulling out bits of legislation and applying them to a hypothetical scenario. With those, I think those are a better example of what I'm trying to say here. What you want to be familiar with is the key bits of legislation that we've talked about. So, Animal Care and Protection Act, Nature Conservation Act, these kinds of things. And you want to be familiar with some of the key sections, but you don't necessarily have to know the absolute intricacies of every last little section. Instead, what I'd encourage you to do as part of your revision is, just familiarize with yourself with the key questions that we've talked about in class, and then practice using the tutorial questions, practice being able to dive into the legislation and find the information that you need and use that to apply to a hypothetical scenario. And the reason I suggest that is, absolutely. It's across the 11 weeks or 10 weeks of content. There's a lot of stuff to try and revise and get your head around. But if instead you focus on finding out how to find out what you need to know, and, condensing your notes and simplifying your notes so that you're not trying to remember things, you're trying to make it easy for yourself to find out what you want to know in the 6-hour exam block. Does that make sense?
Yeah, and the other question I have is, given that it's a 6-hour block, is it based on a 2-hour or a 3-hour exam? How long should it take us?
That's a great question. It's hard to say because I find that everyone kind of works a little bit differently. It's 5 short answer questions. So I'm reluctant to say 2 hours just because I know that it won't take everyone 2 hours, and then, you know, that'll cause some people problems. So I'm not going to say 2 hours, but I think you should probably be right with 3 hours. If your notes are in order, if you're reasonably across the key themes and issues, I would expect that you could get this done in 3 hours, under 3 hours. I'm not going to say 2 hours just in case, but, you know, it's 5 short answer questions. And so, but again, I think doing the tutorial questions as practice will give you a sense of, you know, how long it takes you to do 5-ish questions.
Jake, when you say short answer, have you got a rough word count in mind for answers?
I think what I'll do is I'll save that question for next week's revision, just because I want to have another chat with Alex about exactly what, sort of length and how much detail we're looking for. It's not, short answer doesn't mean pages and pages and pages, big research essay length, but it also doesn't mean 1 or 2 sentences. I will give you a much better and more specific answer next week. For now, if you were looking to do tutorial questions as practice, for now I'd be aiming for maybe 3 or 4 paragraphs. Again, there's a little bit of a difference between the sort of discussion-ish questions and the more sort of doctrinal hypothetical scenarios. But I'm going to say 3 or 4 paragraphs, but that's got a giant asterisk next to it.
Jacob, who wrote the exam? Was it you or Alex?
Both of us. We've been sort of collaborating, and I didn't want to say this just in case, but the expectation is that Alex will be back next week and we'll do this revision, the revision week next week together. But yeah, it's been a combined writing of the exam. Cool. Any other questions for now? So as I said, next week as the revision week, we'll have a really extended chance to talk about the exam and the expectations and everything. If you've got questions in the meantime, of course, feel free to email me as well, or post via Moodle or wherever. But yeah, other than that, we'll press on and we'll talk about the exam in a lot more detail next week. So this week's topic is a really interesting one, thinking about animals and their use in sport and for entertainment more broadly, I suppose. What I normally, as you know, in previous weeks, I've sort of paused to get an initial reaction. But what I think I'll do, mostly because I think it'll just be the most use for you in terms of assessment preparation, is I'll save that discussion until later on, and we'll jump straight into tutorial question 1, which is basically asking you for a case note on 2 recent decisions. The first one being the Crown and Noble, and the second one being Kadir and the Queen. So I thought what will be most used to you is to start with a discussion about those cases and some of the interesting issues and thoughts that have arisen from those decisions. So let's start with Noble. Does anyone want to give us a quick rundown of what the key issues were in this case, or what was going on?
I'll go. Noble pleaded guilty to 15 counts of offences under the Criminal Code, and he was sentenced to 3 years imprisonment, which was wholly suspended for a maximum operational period of 5 years. This case was about the appeal by the Attorney General on the ground that the sentence imposed was manifestly inadequate. The Queensland Court of Appeal dismissed the appeal, concluding there was no error on part of the sentencing judge. He was a well-known licensed greyhound trainer and an Animal Liberation Queensland employed a private investigator, and they'd been tipped off that he was conducting live baiting training. Video evidence had revealed that he was using the training technique, which is banned in Queensland, using small live animals, piglets, possums and rabbits. And they were put through severe pain, suffering resulting from distress, death and injury. He'd worked in the greyhound industry for his entire life, and the sentencing judge had taken into account the fact that he'd been banned from the industry through these offences, and that he'd been vilified publicly as well. So he'd lost his livelihood, and yeah, the Attorney General submitted there was an error of law on part of the sentencing judge and a failure to properly exercise discretion, saying, yeah, and yeah, just considering that the judge attributed weight to matters that they did not properly deserve, and the respondent submitted that the judge did not treat any matter as decisive, and so referred also to the Penalties and Sentences Act that imprisonment should only be imposed as last resort.
Yeah, absolutely. No, I think that's a great summary. Thank you for that. So yeah, really pulling out this key, I suppose, issue over the sentence in general, but in particular the suspension of the sentence as being really what was in issue. So there wasn't too much of a discussion about, or what wasn't in being challenged was the 3-year sentence itself. The key issue that was being disputed was whether it was appropriate that the full sentence had been suspended, and therefore Noble wouldn't spend any time in prison at all, as long as he didn't do anything else in the next 5 years. So that's a really interesting, I suppose, take, because it's going to the heart of, and we've talked about this in previous weeks, around concerns about whether animal cruelty offences are being punished harshly enough and things like that. And this is an interesting focus on something other than just the time in prison itself in terms of 1 year, 2 year, 3 years, but actually focusing on, okay, in practice, how much time is actually going to be spent incarcerated, and in this time, no time is what ended up being handed down at sentencing and upheld on appeal. So I'm interested, that was a great summary. Thank you, Tanya, of the case itself. I'm interested now to hear, I suppose, some of your thoughts and your reactions to that case and that decision itself. Do you think that appropriate weight was given to the different factors raised in terms of his age and his livelihood and things like that, or did you see things a little bit differently?
I think that there was a fairly strong political aspect to the case, because it was regarding the recent enactment of Section 242, and it was the first occasion for the court to pass sentence, and it was brought by the Attorney General. And normally it's very difficult to get an Attorney General to take up cases. Generally, they are more likely to take criminal cases up, but yeah, it can be very hard to get them to do public interest cases, and that was, I guess, what the Attorney General sought to do. I thought it was interesting too that he'd had death threats, and he'd had a bit of trial by media and a bit of rough justice as well. And they seem to bring that into play. And I know that does happen in sentencing, but that can be a little bit frightening. That wouldn't have added to his joy in the situation, I suppose. And also the other thing that struck me too was that the use of baiting of animals has been used historically. And it's interesting because I guess one of the arguments for animal welfare is for animals to be able to, you know, use their natural instincts and that sort of thing. And I guess this is a bad example of where their natural instincts to, they sort of get them to chase rodents and things, that they're using their natural instincts against them and using it in a cruel way. But historically, it was interesting that the court discussed how he'd been brought up around this sort of thing, and you know, it was sort of entrenched for 50 years, and that in Queensland it hadn't been in place for 12 years. So I think it was that, I thought that was interesting that that was being discussed as well, because he was quite an elderly gentleman who'd grown up with this sort of thing, and yeah. But yeah, that was all I think I thought about it. So
Yeah,
it
awesome.
definitely had a.
I also thought it was interesting, Rachel, that it mentioned in there that Racing Queensland was previously aware that he'd been doing it, and there'd been no official warnings or sanctions or anything like that against him. And you would have thought that they would have stepped in a bit earlier with these sorts of circumstances.
Well, I suppose it's because it was a recent enactment and they were really going to make an example out of this chap. And, you know, I suppose that sort of calls on, you know, was he going to get a fair trial? You know, he'd had a bit of trial by media. The fact that, you know, because it was the first occasion that the court was going to sentence something like that. But I do agree with you, they should have stepped in and counselled him and warned him and that sort of thing if they were aware. Because, I mean, that's their job really, isn't it?
Yeah, it's an interesting one, and we won't spoil too much of the other case, but it also raises in the second case that we'll be looking at in Kadir. This was sort of also raised in that case as well about concerns that the sort of regulatory body were, you know, there was a closeness between the regulatory body in New South Wales and the trainers that meant that that the animal, what were they called? The animal welfare folks didn't feel like they could go to the body with the tip off that they'd been given. They were worried that that was actually going to alert them that there was an issue that needed to be sort of hidden away, and so that's why they opted for undercover surveillance and to go straight to the RSPCA. And, you know, not saying that that's exactly what happened here, but it seems to be a sort of, it paints up, I suppose, a similarity that there's a concern that, you know, it was used in this case. Racing Queensland knew that he was doing it and they didn't do anything about it. It does raise an interesting question about why was that? Absolutely. I've made some other sort of notes on what you've said, Rachel, that we can sort of circle back to discuss as well, but I'm interested to hear in other thoughts first.
I picked up the similar thing to you, Rachel, about how the court considered that he had been in the industry for years and he'd been using those techniques since he was probably first starting out. Because, well, I've never done greyhound racing, but I've grown up in the country in New Zealand, and, you know, we've had pegging dogs, and I know some people probably don't agree with it, but we've done that, and like duck shooting and hunting, and it's just a way of life. And yeah, so it's probably the same. Like, I don't know why some of the pig laws aren't harsher, because a lot of times you use the dogs to do to, you know, grab the pigs and all of that, and the pigs are obviously in pain. So I think it's quite similar to the dogs when they get onto these animals that have been tied to the lures. It's pretty nasty. What I also found interesting was that in Section 7 of the Animal Care and Protection Act, it actually talks about a lot of penalties being dealt with outside of the criminal justice system, because the Racing Act isn't actually really considered. It's kind of ignored, and if an offence happens within that, it's not constituted an offence under the Animal Care and Protection Act. So I thought that was interesting, and kind of some people might use it as a bit of a loophole.
Yeah, absolutely. There's some, the way that the exceptions play out, and compliance with various codes and the way that provides an exception and that sort of stuff is a huge element of this sort of week's topic. And in question 2, we sort of will explore that in a little bit more detail, looking at all the different rules and codes and standards of practice and how they combine and capture some activity and not others and things like that. So that's an interesting observation. Anyone else?
Yeah, I thought one thing that was interesting was the trial judge, in looking at factors in mitigation, had put a fair bit of weight on his early guilty plea, and I suppose it links with the second case of Kadir, that about the admissibility of the evidence that was obtained unlawfully, and even though that judgment had been handed down, he still pleaded guilty instead of using that as a way to get out of it. Yeah,
absolutely. And the sort of a theme that runs through the judgment is a sort of the elements of guilt and remorse seem to oscillate a little bit. On the one hand, absolutely, you've got the early guilty plea. There's the attempt to lie about having the pig and trying to hide it, which sort of indicated that what he knew, that what he was doing was wrong and was against the law. But then on the other hand, you had these arguments that this is a fairly embedded practice. He'd been doing it for however long, and that was sort of what he knew, how he knew how to train greyhounds. And so there was sort of an element of, he's old and he's not caught up with the times, and what are you going to do, kind of thing. So an interesting sort of back and forward between an element of and discussion as well, especially from the psychologist, about his sort of being desensitized to pain from feral animals and things like that. So an interesting sort of back and forward between an acceptance that this was wrong versus a belief that this is just the way that we do things. Was a really interesting tension across the judgment. Any other thoughts on that one?
Didn't they also weigh up the fact that he had a wife that was quite sick, and he had some other psychological type things going on in his life where he was also unwell? So they took those things into consideration a little bit as well.
Yes. So there was the fact that he was the primary carer for his wife, who was herself elderly and ill. And also they talked about his history of mental health issues itself. The psychologist kind of talked about, prison's probably not going to do wonders for that, because it wouldn't. And also a discussion that, he hadn't really sort of sought help for those mental health problems before. So he was, unlikely to do so while he was in prison as well. And so, that was something that was brought up as one of the factors as well, which was interesting. We might press on. I was gonna really stir the pot and get you to say if you would have sentenced the same way or differently, but we don't have time, unfortunately, because we do need to get on to Kadir, which is another really interesting case, and really, I won't spoil it. I'll let someone else do the summary. Who would like to jump in and talk about the summary for that one?
I'll give it a go.
Yep.
When I first read it, it confused the hell out of me with which way it went. I was like, oh, hang on.
It's
I thought
yeah,
it was
yeah.
saying one thing and saying like the opposite in the same thing. Evidence, surveillance, I don't know how to start it. Evidence of Kadir's involvement was, there was video footage that was obtained illegally, and then that footage was given to the RSPCA, who they used that footage as a basis to get a search warrant. And also there was also some filmed admissions that Kadir had made. In the court of first instance was the District Court of New South Wales, and Kadir applied to have the surveillance evidence and the search warrant and the admissions excluded, and he succeeded with that, and the trial judge rejected those categories of evidence. And then the DPP appealed against that judgment at the Court of Criminal Appeal in the Supreme Court of New South Wales, and the Court of Appeal held that the trial judge didn't weigh up the balance of how difficult it would have been to obtain the evidence lawfully, and in relation to some of the first surveillance videos. And then Kadir appealed to the High Court, and the High Court unanimously held that the surveillance was inadmissible, but that the other two types of evidence were admissible.
Yep, absolutely. So, yeah, as you say, sort of a little bit of back and forwarding between the different judgments and the different levels of appeal. But yeah, basically we've got the surveillance evidence, which was the initial undercover sort of filmed footage of the live baiting, and that was obtained unlawfully because it involved Ms. Lynch trespassing to set up cameras, and the filming occurred without Kadir's permission. Based on that evidence, they took that film to the RSPCA, and the RSPCA said, okay, well, I've got grounds to investigate. They went and got a search warrant, went to the property and found, I think they found a few dead pigs and an alive pig that had been injured. So there was that sort of the search warrant evidence, and then there was the Ms. Lynch then called up Kadir and pretended to be a greyhound owner and said, oh, I'm interested in getting some dogs trained, what do you do? And the allegation, it seems like that conversation itself wasn't actually recorded, but there was, based on her testimony, she said that he admitted that that he used live baiting as part of the training and stuff. So those were the three sets of evidence. And what was part of what really sort of was at issue in this judgment was the surveillance evidence was very clearly unlawfully obtained, right? It was Lynch trespassed to set the cameras up. There was no permission. There was no dispute that was unlawfully obtained. What was more tricky was whether the search warrant evidence, whether that was as a consequence of the unlawfully obtained surveillance evidence. And what the High Court really emphasized in this one was that because they didn't knowingly participate in the unlawful surveillance. The search warrant evidence itself wasn't sort of tainted by that unlawfulness. And equally, the what they call the admission evidence, the phone call pretending to be a greyhound owner, that also wasn't tainted by the unlawful surveillance evidence. That was something that, you know, Ms. Lynch or anyone could have done off their own bat without having seen the surveillance evidence. And so that wasn't unlawfully obtained or obtained as a consequence of the first unlawful set of evidence as well. So 3 different types of evidence and 2 different ways of dealing with them. The first being unlawful and not admitted, and the second 2 ending up being able to be admitted. Any other interesting sort of thoughts or takeaways from this case?
I thought it was interesting. There was some discussion about the difficulty with obtaining evidence of these sort of matters, and there was quite a bit of discussion about, as you said, like the first video, but then there was multiple other videos taken. So whether they could have potentially used that first video to go to the RSPCA without taking the steps of multiple other occasions, could have more or less, in my mind, taken the court to going, well, you know, they overdid it a bit insofar as they could have taken the first part to the RSPCA and said, well, it's difficult to obtain evidence of this. This is what we've done. You can now investigate.
Yeah, absolutely. There's two points that I want to talk about with that. But the first one is what's really interesting is that that's the approach that the Court of Appeal took. So, you know, we think about there was the trial at the District Court, then there was the Court of Appeal, and then there was the High Court. And we've got the High Court judgment, but the Court of Appeal, that's the approach they took. They would have allowed the first surveillance video and then disallowed all the subsequent ones, but they actually said that the first one would be okay. Then in the final appeal to the High Court said no, none of the surveillance. So that first one wasn't allowed either. So yeah, that's a really interesting take, is thinking about the difficulty of obtaining the evidence, and as a consequence, thinking about, yeah, is that first one a little bit different to the subsequent ones once she'd kind of been in there, and then the repeated return and the repeated trespasses, thinking about whether that's different or not. The second part that I want to really draw your attention to is, and I'll just share the screen. There's a discussion that I would like you to have a look at. So this is the bit that I've highlighted here. This is from section 138 of the Evidence Act, talking about exclusions for improperly obtained evidence. And this paragraph H is what they're talking about in thinking about the difficulty, if any, of obtaining the evidence without impropriety. And what the High Court was not thrilled about, you can kind of see that they're not happy that they had to really spell this out, but they were really they were concerned that at the lower courts, that section H had not been applied in the proper way. And in the lower courts, that difficulty of obtaining things properly was interpreted as meaning, if it's really hard, then we should allow it to be admitted. You know, if it's hard to get, then we should tolerate a little bit of unlawfulness to get it in the first instance. They actually said, no, you've got H wrong. What H actually is referring to is if it would have been actually really easy to get things properly, then, you know, we don't want to cut corners, they talk about. We don't want to encourage cutting corners. But at the same time, if it really wouldn't have made any difference if they'd just done things properly, then it shouldn't impact the admissibility of the evidence. So they talk, it inverts the policy of the exclusion for which section 138 provides. So this is, the difficulty of obtaining evidence is something that was really pulled out in this case and was something that was an issue, but it's something that the High Court really didn't agree with the way that it had been handled in the lower courts. So that's, I'll stop the share so we can have more of a discussion of that. But I think that that's a really interesting point to raise, because that's something that we've sort of talked about a few times now in this unit, about the difficulty of obtaining evidence in these kind of animal law disputes or cases or whatever, is actually thinking about, okay, how do you prove this stuff? How does the RSPCA, you know, go in and enforce these provisions? How do they find evidence of wrongdoing? I think the discussions, there's been a consensus that it can be quite hard to prove some of this stuff. Here, potentially what we've got at the lower courts is sort of interpreting this as being, okay, it's hard, therefore we'll, you know, allow a bit of lenience. High Court coming around and saying, no, what you should be thinking about is, if it was easy and it probably wouldn't have made any difference, then that shouldn't bar the evidence from, or the conclusion from, being reached. I'm interested in your thoughts on the case specifically, but then the broader point about, you know, the role of evidence in animal law cases, and you know, how we go about obtaining that.
With the case, I originally agreed with the lower courts in that. That's how, in my mind, that made sense. Like, yeah, if it's really difficult to obtain evidence legally, then you, in my mind, that would have weighed for admitting illegally obtained evidence, until when I read the High Court reasons sort of, I guess, more thoroughly. And yeah, the way they turned it around and said, no, if it's easy, then that would be more likely to be admissible. But yeah, at first thought, I sort of, I agreed with how the lower court had interpreted it, really.
Absolutely. Anyone else?
Yeah, the thing that I thought about it was that basically because they were relying on section 138 of the Evidence Act. New South Wales and the Commonwealth have a Uniform Evidence Act. This probably wouldn't have flown in Queensland, which is based on common law evidence, because the Evidence Act that they referred to was quite specific and allowed for a balancing up of public interest and that sort of thing, and the probity of the evidence and all that sort of thing. And so they were able to, I guess, allow something into that. I think if this was in Queensland, they would have a lot more difficulty, and a good barrister would have that disallowed. And basically all their case would have fallen apart due to no evidence, as it had initially, I guess. And so I just think that's interesting because of the Uniform Evidence Act and the way it was used there.
Yeah, absolutely. The jurisdictional element, thinking about, you know, so at common law, you've still got Bunning and Cross to sort of think broadly about, you know, the probity of unlawfully obtained evidence. But yeah, you're absolutely right. It's the New South Wales Evidence Act being very explicit about, you know, here's the things you need to think about, and, you know, the full list. These are the factors to weigh. Absolutely plays a role in the way that this case played out. Definitely.
I think also too, there was an element of with the admissions that were made, they weren't made to a police officer. and basically, like, it was a self-incrimination and admissions. And even though she was able to give evidence, it's one person giving evidence. And so I'm a bit concerned about that too, because of whether it's, what weight that could be given as well.
Yeah, that was a tricky one. And I if I can find the part where it's discussed, because my initial thought was, oh, okay, she must have been recording the call, but then I couldn't
They
actually.
talked about the fruit of the poison tree. I'm pretty sure that stands in Queensland, doesn't it?
It's
See, she was using subterfuge to try and trick him into admitting things, but she's not a police officer or a regulatory body or an actual investigator. It's just like some person down the street,
Yeah,
doing this.
it's difficult because in Queensland we've got the Police Powers and Responsibility Act, which absolutely governs the way that a police officer should be conducting, questioning. But it is a little bit different. I'll just pull up my screen again. And so this is in relation to the admissions. Miss Lynch, is the private investigator, arranged to speak with Mr. Kadir. She called, she posed as a greyhound road, and he's alleged to have responded. And I took that as meaning that there wasn't actually a recording of that conversation, which is interesting in itself because it does sort of raise a little bit more questions over the way that the weight that should be given to that evidence and things like that. But absolutely, the way that the questions were put to Mr. Kadir from the private investigator, there's some discussion in the case about using false statements to sort of lure out a confession and that as well, which is really interesting.
It's a criminal case and they have to prove beyond reasonable doubt. It's a pretty high standard, and I just think that it would have been a bit different in Queensland. On another point, was I thought it was interesting that the Chief Investigator of Animals Australia was a former police officer who engaged someone to trespass to gain the evidence.
Yes. Well, there's the discussion of that, sort of thinking about, and this is why I was talking in relation to the Noble case as well, about her impression that it wouldn't do much use to go straight to the RSPCA or the police with her concerns. Her assessment was that a judicial officer was highly unlikely to issue a surveillance device warrant based purely on the kind of anonymous tip. So that was the anonymous complaint, was the tip to Animals Australia in the first place. And so drawing on her experience, she said, look, if I go to the police with this, they're just going to go to the RSPCA. And her concern was that the RSPCA had an understanding with greyhound racing that information given to the RSPCA would be shared, and she was worried that that would then tip off Kadir. So it is really interesting the way that her experience as a police officer, and the way that she used her experience and her insights to the course of action that it did,
couldn't it? Or counselling someone to engage in a criminal offence or things like that. I guess at least she's not a police officer anymore, but I guess Animals Australia needs to be a bit more careful.
It's difficult, and especially because, and I mean, private investigators themselves, it's a, let's say, grey area, and the way that elements are dealt with at arm's length and things like that. So there's my expectation was that there would have been enough plausible deniability built into that contract to, and you can have your views about whether that's right or not, absolutely. But in terms of tracing it back to the Director of Animal Australia, that's tricky. But it was interesting to note in the decision itself that there were no plans to charge the private investigator for the trespass offence. That was sort of explicitly mentioned in the judgment that wasn't on the cards. So that's another element of this puzzle too, which is interesting.
And you know what that reminded me of was which we learn about in torts, like first year, the ABC and Lena Game Meats case, which was in Tasmania. It was the High Court case from 2001. And in that case, it says they were unknown, but they must have been animal activists. And they snuck into this factory. It was kind of like an abattoir for possums. And they put cameras around and they videoed how these possums were being killed for their meat. And it was really inhumane practices. But when this went to court, the court actually sided with ABC and said that they didn't really have a problem with the illegally gained material being broadcasted. And they didn't grant the meat place, the Lena Game Meats, they didn't grant them with the injunction to stop that stuff being broadcasted. And that kind of reminded me, because they trespassed, they gained this footage in a similar way to how they did in this Kadir case.
Absolutely. There's a rich history of videotapes and USB drives mysteriously appearing on doorsteps with footage, which is itself interesting. But what I think is really interesting that this speaks to is the broader then consideration about how we weigh up the public interest in finding out this information and being made aware of the live baiting that was going on, or the issues all the way back in Lena Games Meat. Same tort versus criminal, so it's a little bit different, but similar broader debate over, is it in the public interest to find out about these problems, and how do we weigh that public interest against the public interest of a right to privacy, a right against trespass, those sorts of things. And ultimately what it boils down to in this case was that the public interest in the search warrant evidence and the admission evidence they specifically said that in the judgment, those outweighed any concerns that there might be about the way that evidence had been obtained. But in the case of the surveillance evidence, that undercover video footage, that the public interest that came from that specifically was stated to not outweigh the public interest in a right to privacy, a right against trespass. Well, not a right to privacy, but a right against trespass and the protections under the Surveillance Act. So that's, that in itself is really interesting when we think about evidence in animal law and think about, these broader issues about how do we prove these things, how do we find out information when it's, a lot of it's occurring on public property, private property. Weighing these competing public interests is, hugely relevant, and I think that Kadir is a really useful case to think about the process of weighing those competing interests. Any thoughts on that in the last couple of minutes?
I think it's turning into vigilante justice. Because, just traipsing over people's farms and properties and all that sort of thing. I know that the federal government and also Queensland government tightened some of the trespass laws and increased fines and that sort of thing. But Yeah, ex-police officers and, you know, hiring people to sneak around, and they trespassed 11 times, and like it's not good. I
Yeah,
mean,
and that's
where does this go from a justice point of view? I mean, where does it stop? And then, you know, this sort of thing can get out of hand.
yeah,
But then
it's
on the other hand, on the other side of the coin, if you look at all the, I guess, the developments and improvements that have been made in lots of areas, such as live exports and stuff, all of that came about because of people breaking the law and obtaining evidence illegally. And then the media investigations and stuff that came out of that. None of those changes would have occurred if people hadn't broken the law and did what they did in the first place with you know, obtaining the footage.
Yeah, but it also destroyed a lot of people's lives. There was suicides. There was a lot of people went under because they lost the export, and it was through no fault of their own, and things that were out of their control, and certainly things that they weren't responsible for themselves. And the government just locked down and didn't consider the ramifications, and they've had to compensate for that, I believe. So yeah.
Yeah, it's a tricky, absolutely. And we're out of time, but just the sort of very tip of this discussion shows that it's absolutely a complex and very multifaceted issue. And it speaks to, I think, the ideas that we've been talking about all term, really, in terms of balancing, human and economic interests with the interests and the welfare of animals, balancing, these rights in terms of us as people, our right to, a public discourse and an informed public debate about these issues versus people's individual rights to, not worry that their homes are being trespassed every night. It's, absolutely, it's a complex thing, and it's a conversation, I think, obviously, that's been going on for a long time, but one that I think is, building and heating up, and one that I hope over the past few weeks of this term, you may be, more equipped to participate in and see things in a bit broader context, which I think is really interesting and really cool. We are out of time. Obviously, we haven't had a chance to go through question 2. I'll pop up some thoughts and some discussion points in that over the next few days as well, just to make sure that you've got some ideas in relation to that question as well. Other than that, yeah, the only thing that I would say is to really just emphasize, thinking about the way that the Kadir case, kind of what it tells us about the use of evidence in animal law proceedings, and thinking about, the way that we weigh up these competing interests, as I've said, is really fascinating. But other than that, any final thoughts or comments? Excellent. Well, thank you all very much for coming along. We'll see you next week for that final revision. So yeah, just a reminder, that's planned as a 2-hour tutorial. So we'll have more than enough time to go over all the questions and comments, and to reflect on everything that we've been talking about over the last 12 or so weeks. So have a great week, everyone, and we'll see you next time. Bye.